responds differently to white people when they have questions that are not offensive to him. He also cherry picks things and comes back later and broadcasts them himself that I attempt to respond to here, and he cuts me off. That doesn't get dismissed on a 12b6, Your Honor. I'm sorry. That's kind of summary judgment for me on Rule 56 when you look at what he just did. Now let's go to the issue number 2 with Defendant Vollendroff and what under the state and federal constitution. I'm suing under the state constitution. It is my right not to be treated like that. He threatened to have me escorted out, Your Honor. In my declaration, I have nightmares about that. I'm a 60-year-old black man, doesn't have a criminal record in this country. I went to law school. I used to practice. I used to work for law enforcement. I respect the law. I honor the badge. And to threaten me like that, my partner would get up and testify at trial that I had nightmares about this after he did that to me. That's inexcusable. The fact that I published a lot of times doesn't matter either. They could argue that that makes these incidents de minimis, but that's up for jury to decide whether or not it's de minimis. Those nightmares I had were not de minimis. And right here, there's the cited case that governs is Rayford versus Owens. It's a partial. You don't have to have a total shutdown of speech or video or anything of that nature, as long as there was a substantial interference, and that certainly happened. The court heard it. Everybody's been hearing it online. It happened, and they need to, atone for it. Okay.
Okay, 10 minutes starting now. Go for it.
Great morning, Your Honor. We all know that the law does not happen in a vacuum. Cases don't happen in a vacuum. Now, the context that this court needs to know about here, in the first instance, is that David Postman, the defendant Postman, set the entire stage for the discussion that I was attempting to have with him in the first video. He publicly criticized me, primarily, and other people, saying that we were issuing personal attacks against members of the board. Okay, so we've defined what the subject matter is. It's content and viewpoint based right off the bat. And that's what this is all about. So when I'm asking him, in the first hearing, I'm disagreeing with him that I did anything personal, and I'm pointing out why I didn't think I did so. So then I stopped to ask him, do you think that those actions constitute personal attacks? He doesn't answer me, which he doesn't have to do. But he says, are you done? And I said, no, I'm going to take my whole time. And he says, no, you're not, we're done. And then he started talking over me for the duration of the next 30 seconds that I had to speak, and my time was up. So as I filed with the court, the responses from the defendant and counsel to my discovery request about that were not truthful. I never got to finish what I wanted to say. And it's point blank. So, what can I say? From the beginning, ipso facto, ab initio, that is the thing in itself, right there. Let's throw another one in. The sine qua non, let's throw them all in, Your Honor, because that's what we have. And it's undeniable that the issue was content and viewpoint based. And I couldn't finish my talk. And it was done with anger. And so this type of malice and anger done by him and in Section 2 with Defendant Vollendroff, that takes their conduct out of the role of some type of, it takes them right into individual liability is what it does under 1983 analysis, which is applicable here, relatively. So let's play number 1 for you.
Attacking people and all this and that, sometimes, you've said that I've attacked Board Member Garrett, for example, and some of your black sycophants who come before the board. They say that I'm attacking Ali Garrett by asking simply what happened to the letter that Kevin Shelton and Ben Shelton sent her at the behest of Nate Miles. So that's not attacking anyone. That's asking what happened to a public document. That's all. So I don't get where people are saying that I'm attacking them. That's not really an apt judgment, period. And let's turn to the incoming director, Lucayla. I didn't attack him either. I just asked questions that journalists ask, okay? So I'm taking my time on vacation to address you about this because I even said last week, look, he might be responsible for starting the loan program down there. That's a positive comment, and I meant it. If that brother was responsible for that, that's a good thing. I'm just not sure. So what I did was I took the liberty, as you may know, of asking for concrete items from you. I put that in a public records request.
Okay, now that part has been withdrawn. But the point is, I'm responding to something he put out there first. He positively injected that into the stream of, audible commerce, discourse, and I'm responding to him. Then he delimits my ability to do so, right here.
I I wrote for the Indianapolis
So
because
then he
I
says,
saw it says last week, and I'm like, I talked about so much more than that. Why was that important? Do you think it's unfair for me to ask for those things about Director Lucayla? Do you honestly feel that I'm attacking you?
Christopher, you got 30 seconds.
bless you.
Thank
John.
you. Do you honestly feel that I'm attacking you for asking for those things?
You done?
No, I'm going to take much more time.
No, you won't. Okay, we're done.
Oh,
Thank
no,
you.
really? Is that how it's done?
No, we've told you this before, Christopher. This isn't, you talk about being a journalist. This is not a press conference. You have questions for us, you can ask them.
Let me explain it to you.
Talk,
I'm
no,
allowed
4
to
minutes
have a
to
dramatic
sit on
pause.
line.
It's called a dramatic pause. I will address you how I care to address you, as long as I don't swear at you, okay, or threaten you. I am allowed to have dramatic pause as a component of my presentation to you. Period. You know that. Goodbye.
Now, my time was up. All that time is spent arguing with him over something. He's a public official, Your Honor. His job, unless I violate time, place, or manner, his job is to sit there and listen to me. That's it. And so while he says that he doesn't respond in a Q&A form during real time, I have discovery out there. We'll show you that he responds differently to white people when they have questions that are not offensive to him. He also cherry picks things and comes back later and broadcasts them himself that I attempt to respond to here, and he cuts me off. That doesn't get dismissed on a 12b6, Your Honor. I'm sorry. That's kind of summary judgment for me on Rule 56 when you look at what he just did. Now let's go to the issue number 2 with Defendant Vollendroff and what he did. You can hear that. I have my camera. It's in it's on a gimbal, and I'm just walking. First I'm seated, then I start walking through the room. I'm not talking to anybody. You can see the declaration of a witness who was there that I filed. I'm just walking out the door, and Defendant Vollendroff stops me.
I wasn't aware that we started the meeting.
Well,
I mean, we started the meeting?
we haven't technically started.
Okay then. So, all right, don't get off me, man. All right, thank you.
Is that too much?
I was just gonna ask Director Lucayla if I could get that CV now, because I've been waiting for it about 4 or 5 times.
This is disruptive behavior, and if you don't stop,
But
I'm asking you to be escorted.
How am I disrupting anything when the meeting hasn't started?
I've asked you to sit down.
I don't want to get hyper-technical with you, but listen, I'm a lawyer. He's a lawyer. John, you're a lawyer, right? How have I interrupted a meeting that hasn't started?
So
Don't mess with me,
the
guys.
lawyer leans over.
Okay, we are officially starting the meeting.
And I'm sitting down, am I not?
Okay, thank you, I appreciate that.
I'm in my place with a bright, shiny face.
So when your time comes, we'll let you have that floor.
Oh, thank you. It's a constitutional right. Appreciate it.
And it is. Under the state and federal constitution. I'm suing under the state constitution. It is my right not to be treated like that. He threatened to have me escorted out, Your Honor. In my declaration, I have nightmares about that. I'm a 60-year-old black man, doesn't have a criminal record in this country. I went to law school. I used to practice. I used to work for law enforcement. I respect the law. I honor the badge. And to threaten me like that, my partner would get up and testify at trial that I had nightmares about this after he did that to me. That's inexcusable. And the bigger issue here is that Attorney Gelms, in his response back in discovery, he indicated that Vollendroff was warning me because I might be about to cause a disruption. No, if you go back and look at the timeline, he told me I was flat out causing a disruption when the meeting was not even in session. And furthermore, I'm allowed to run video while it is in session. So once again, just like Defendant Postman, while I'm doing my job, Your Honor, Defendant Vollendroff needs to keep his mouth shut. Now, to close out, let's real quickly deal with the Gamillion issue in terms of the general injunctive relief that I seek on behalf of Black and Brown. Because the problem here is that for 10 years, we've had this system where we had a licensing system and we had like 500 some whites got their licenses under I-502. There are many lawsuits, successful lawsuits and pending now about how 502 is rigged. And blacks never got a chance to participate or to be stakeholders and come before the board and produce things orally. You know, in this type of environment, that's the point of this type of petitioning of the government, okay? They never got that chance. And for 10 years, whites got that chance. And now under Gamillion, you look at the impact of what that means. It means that black folks, when we finally get these 170 licenses that are allegedly supposed to be shipped out to us, we won't have had that chance. You know, it's as if they consider us trespassers on their property. And Your Honor, the last thing, I'll reserve a couple minutes of my time, they do look at us as trespassers. They don't like what we say. They don't like how we say it. And the case that they cited, in this case, Patterson, that guy was a trespasser. He showed up at a time when he wasn't on the docket. You know, he could have been an invitee or licensee to start with, but once he interrupted court proceedings, he became a trespasser. I, on the other hand, was at the specified venue at the specified time doing the specified thing. I'm not a trespasser. I am not a criminal, and I refuse to allow these people to treat me as such.
And you
Nor-
have 1 minute left.
Yes,
You wanna say the minute?
yes, and nor should this court.
Okay. And
Thank you, Your
can
Honor.
you hand me the flash drive so that I have that to review?
Indeed.
Thank you. Appreciate it. Thank you. Okay, counsel.
Thank you, Your Honor. Is it okay if I approach?
Yep.
Thank you. Thank you, Your Honor. Once again, Jeremy Gomes representing the defendants and LCB in this matter. LCB does ask the court under 12b6 to grant its motion to dismiss and accordingly also grant the motion, deny the motion for preliminary injunction under the basis that if the motion to dismiss is granted, they obviously, Mr. King cannot show he is likely to prevail. The complaint, as alleged, presents no legally cognizable claim and it's deficient as a matter of law. I want to specifically go down what is actually alleged in the complaint. First, in paragraphs 24 to 30, we have the allegations regarding the interaction between Mr. King and Mr. Vollendroff in January of 2025. The complaint alleges that he was moving around and that Mr. Chair Vollendroff said, quote, it was kind of disruptive to have him walking around. King approached LCB Director Lucella at that point to ask him for his CV. The director did not respond. The board was in recess. It was called back to order. He sat down. The meeting continued on. He was allowed to speak and continue to record. The second allegation is in paragraph of the complaint 47, where he claims that the board installed a, quote, rent-a-cop and a black tape barrier in front of the board. Paragraph 45, he also claims that there was a transition from in-person public comment during meetings to written comment. And finally, we heard from Mr. King today about an interaction between himself and Mr. Postman. I do think it's important, though, if the court looks at what is actually pled in the complaint, in paragraphs 3 and 22, those are the only mentions of Mr. Postman. And what is, quote, alleged is a conclusory allegation that he, quote, Mr. Postman has a practice of engaging himself in conversations with black and brown people, and below are 2 videos in which he did so in hostile and unprofessional manner. There's no linked videos or any indication in that, so that is a conclusory allegation. There is more detail regarding those alleged incidents in his responsive briefings to the court, as well as in a supplementary declaration, but those are not part of the pleading record. So essentially what we look at here, Your Honor, is that there are allegations of 3 sections of Article 1 of the Washington Constitution that have been violated. Section 3, Mr. King's personal rights, Section 4, petition and assemblage, and Section 5, freedom of speech. You didn't hear from Mr. King a discussion about the transition from public comment, from oral to written comment, but as the court is probably well aware and has said in this brief, the OPMA only requires public comment to occur when final agency actions are taken. LCB traditionally and historically has had a very liberal public comment session, allowing up to 4 minutes, then transitioning for 3 minutes for anybody who signed up at any meeting. For efficiency purposes and in consultation with the OPMA, they transitioned to a written comment policy that is applied to everyone. Mr. King does not allege otherwise that certain people are subject to that policy or that certain viewpoints are subject to that policy. Everybody is subject to that policy. From a standpoint of what he has to properly allege for purposes of the 3 violations of Article Section 1 is he must demonstrate that there was an unreasonable viewpoint restriction based on speech. And here, when the court looks at the allegations, there's simply no allegations that are alleged in the complaint of restricted speech. There's nothing claiming a denial of an opportunity to speak, nor specific allegations, as Mr. King describes it as, quote, black and brown people who have been excluded or prevented from speaking at meetings. What we have here at most, I would argue, is that an interaction with Mr. Vollendroff that at most rises to the level of a disagreement, but in which Mr. King continued to be remaining present, recording the meeting, spoke during public comment. And even if the court were to consider the allegation against Mr. Postman, even though it wasn't properly pled, the court can review. This also interaction does not rise to a constitutional violation. He spoke for over 4 minutes. He ended the interaction on his own accord. And frankly, Your Honor, what we do have when we look at the complaint is we have a complaint that is flush with links to Mr. King's cast, where he records all of the board's meetings, which is well within his rights. But what you see from that is that he is permitted to record the meetings, he's permitted to speak at the meetings, and don't believe it turns it to a summary judgment motion, because the information is publicly available on LCB's website in compliance with the OPMA. The LCB's meetings, agenda, minutes, and recordings are on there. And what the court will observe, as was noted in our response and reply, is that Mr. King has attended 56 of the last 64 LCB meetings, and at every single one of those, he was allowed to video record, and he signed up and spoke at the public comment session. Again, as alleged, this is legally and factually deficient to move forward beyond the motion to dismiss stage. LCB and the defendants do ask that you grant its motion. We understand that the court would like to review things and not rule on the bench today. Understanding that, LCB does additionally ask the court to stay discovery. We currently have discovery that's due on May 29th. If the court is not prepared to rule by that date, we do ask that it be stayed and told until the court rules on the motion to dismiss, considering this would be the second round of discovery that LCB has been subject to so far in this litigation. Thank you so much.
Thank you, Mr. King. You got the last word, 1 minute.
Your Honor, that discovery is going to show that I didn't violate any rules, therefore there was no reason to interfere with me, number one. Number two, the matter with Postman was referenced. If I need to go back and file an amended complaint, so be it. The case is 2 months old, Your Honor, and realistically, okay? So that issue happened, and it's a cognizable issue. And the fact that I published a lot of times doesn't matter either. They could argue that that makes these incidents de minimis, but that's up for jury to decide whether or not it's de minimis. Those nightmares I had were not de minimis. And right here, there's the cited case that governs is Rayford versus Owens. It's a partial, you don't have to have a total shutdown of speech or video or anything of that nature, as long as there was a substantial interference, and that certainly happened. The court heard it, everybody's been hearing it online, it happened, and they need to, atone for it. It's simple. And as far as the greater good, or the greater issue of what happened with Black and Brown in terms of not being able to come before the board does have discretion to look at the adverse impact given the 10-year history of public comment being allowed to all these whites versus what's going to happen now. We never got a chance, much less a 40 acres and a mule, we got silenced, and they continue to silence us because they don't like what we have to say. And I think the court is well aware of that, and it's illegal, and if I have to file an amended complaint, I'll be more than happy to do it. I'm a little rusty. Thank you, Your Honor.
Thank you. Okay, so court's taking the matter under advisement. I have the thumb drive. I will go review it, and I'll make sure to get added into the record. Mr. King, we got a little USB to USB-C. I don't think I need that.
Need it, yep.
You can use that for another purpose.
Sure.
I got an old school USB.
All right.
Little doohickey. So, I'm taking that under advisement. I am going to stay discovery at this point until I issue the ruling. Once you get my ruling, which should come soon, then the stay of discovery is lifted. So I might issue a ruling before then, and then it's all basically moot. It wasn't really a stay to begin with, but I might issue it after, in which case, until you hear from me, you don't need to worry about discovery.
Sorry, like I say, this basically I asked them to show me rules that prohibit me asking questions, so many rules that prohibit me. I can run a video at any time, so why are you bothering me? So I asked for those rules.
Understood.
Yeah.
Okay, so, you're all free to go. I got what I need and we'll be in touch.
Thank you, Your Honor.
Okay, we got one last
Oh, thank
case.
you so much, Mr. King. You have a good rest of your night.
Indian School and Smith et al. Stoner and Ms. Cook are both on Zoom. Good morning. And so, okay, this is 24-2-2515-304, just identified the attorneys. So we have a motion for protection order, a motion to compel. Regardless of the order in which things were